Your Right to a Jury Trial, Some Questions and Answers. Brought to you by YourLegalLegUp.com, your advantage if you're being sued by debt collectors. Under the 7th Amendment, you have a right to a jury trial for cases involving damages. Damages is a little bit of a term of art in this sense, but it basically means money for claims that were traditionally brought in courts of law as opposed to courts of equity. As it happens, breach of contract, which is what most debt cases are, is a legal claim subject to the 7th Amendment. Claims brought as, for example, a claim of account stated are equitable claims that don't give you a right to a jury trial, on the other hand. This all means that if a debt collector is suing you for breach of contract or open or closed account, you have a right to a jury trial under the Constitution. But if they are suing you exclusively for account stated, on the other hand, you don't. Remember, when you have a right to a jury trial for one claim, you have a right to a jury trial for all claims, so that if they sue you for breach of contract and account stated, you'll have a right to jury trial for both. Most debt defendants do have a right to trial by jury. Should you demand a trial by jury? I usually think so. Trials by jury force the judge to take the law of evidence more seriously. In fact, they take jury trials much more seriously in a lot of ways, and that benefits the debt defendant because our cases usually that the debt collector does not have any evidence that follows the rules of evidence, and we need the court to take that rule in particular very seriously. I also suggest demanding a jury trial because they're far more difficult for the debt collectors. Understand what I'm saying, though. It isn't that debt collectors don't know how to do jury trials, or even that they aren't good at them. Individual talent varies, of course, but in general, their lawyers know very well how to conduct a jury trial. I'm not even saying that jury trials are harder. They really aren't. I'm just saying that debt cases tried to a judge can take 20 minutes, while picking a jury can take hours, usually does. All the rules have to be carefully followed in jury cases, and there are a few special rules and procedures, too. So a jury trial might require 20 times as much attorney time as a judge-tried case. And time is money, especially attorney time at $250 an hour for debt collector lawyers. Debt plaintiffs don't like cases that take a lot of time. It increases their costs, and they know you don't have much money, so they worry about whether they can ever get it back. Also, debt collector lawyers also have their own worries about cases taking a long time because the money they collect affects their annual pay, and long debt cases hurt the lawyers. In my opinion, these are strong reasons to seek a jury trial, and there will be times when a jury is also more sympathetic to the defendant than a judge would be. And judges haven't faced debt trouble for a long time in general by the time they've become judges. And most jurors, on the other hand, will have money worries. So why might you not want a jury? The only reason I've ever heard from debt defendants is that they're scared of them, and I do hear that a lot. However, ironically, almost everybody I know who has ever had a jury trial has said it wasn't scary, not when you're doing it. They are a little scary to think about and get ready for. Pretrial jitters are normal, but once the trial starts, you'll be too busy to be nervous. The same is true of judge-tried cases, by the way. The fear goes away much faster than you'd think once you're there. So, how do you ask for a jury trial? You have a right to a trial by jury, but how and when you ask for it can make a difference. In some jurisdictions, you just put it at the end of your answer, a demand for jury. In some jurisdictions, you have to enter it as a separate request, separately. Which of these you'll need to do is probably in your court's local rules, but you might ask a court clerk what they prefer. If you can't get an answer from authority, I'd suggest putting it in both your answer and making a separate request, which you submit at the same time as you send your answer in. What if you didn't ask for a jury trial, but want one now? Is it too late to do that? Probably not. The law favors jury trials, but individual judges often don't, since they know as well as I do that jury trials take much more time and attention. For that reason, if you haven't already asked for a jury trial, I suggest that you do it ASAP. Time matters on this. The number of days could matter, but since a court's discretion to deny a request for jury is probably tied to how long the case has been going on. Now, I'm not saying that there's any magic date, and I would suggest that if you want a jury trial, no matter how long it's been since they filed the case in the first place, I think you should ask for it. But you will have a better chance the quicker you bring your motion. You should do a little research before filing your jury demand, because if you don't do it right off the bat, you'll need to file a motion that tells the judge why you should get one. That isn't complicated, but you'll want to know what the rules are that apply to it. You'll need to tell the judge what those rules are. Helping people protect their rights is what we do. Protect what's yours and don't let the debt collectors rip you off. Take action to protect yourself from the debt collectors and help others do the same. Please like this video, share it with anybody you think could use it, subscribe, and comment, as all these things help other people find our materials. YourLegalLegUp.com